25-7025 FH, aggravated stalking, habitual second, 7.5 year statutory maximum, and a 7 to 28 guidelines range. Counsel, want to state your corrections, please?
Melissa Goodrich, Wayne County Prosecutor.
No, Nightingale from Mr. Claypool appears in person in custody to my right.
All right, good morning. Mr. Nightingale, have you had a chance to review the report and recommendations with your client?
I have, Your Honor. He did hand me just a list of corrections that he thinks need to be made, and so I'm referring to that right now. If I may have just a moment.
Sure.
Thank you. Sorry about that. So as far as some of the corrections that need to be made here, he does have a psychiatric history, and so CFJ 145, page 1, under personal history, where it says psychiatric history, should say yes.
And that's reflected in the mental health narrative on pages 14 and 15 about some childhood treatment, and then up through 2015 it says attending community mental health, but then looks like since then not really any medication or treatment. This report was written by Agent Lesky, but Agent Martin, to my understanding, right on the first page on the CFJ 145, where it just lists psychiatric history, yes or no, is that limited to when there's any hospitalization or when there's current treatment, or is that flagged yes anytime there's a description of diagnoses in the mental health narrative?
If we have a verified diagnosis, either in the past or current treatment, with verified diagnosis, then we put yes.
Okay, but just a self-reported description of things in the past 10 years ago or not doesn't usually flag that then?
No.
Okay. Yeah, and that was sort of my understanding, is that the self-reported aspects of that are laid out in the mental health narrative on pages 14 and 15, but that sort of the toggle yes or no on the cover sheet is when we've got like documented hospitalizations or treatment.
Okay. Okay, fair. Sorry, I wasn't trying to cut you off, Judge. So yeah, as long as I can make that argument, of course, I think we're okay with that. As to, looks like CFJ 284, page 12, his daughter's birth date is incorrect. That should be October 28th of 2010. That's in the marriage narrative, paragraph 2.
Okay, so Agent Martin, can you request a change on page 12 of the CFJ 284, the birth date in the second paragraph, instead of August 28th, if that could list October 28th.
Okay.
Go ahead, Mr. Nightingale.
He also does advise he has a driver's license. Somewhere it says none in here. I couldn't exactly find it.
The first page, the cover page. Driver's license. Yeah.
Okay, it's also on CJ 101, page 1.
It says driver's license none.
Correct.
That's a.
I'm not sure if that's one of those that they have to verify it, but
Yeah. All right, so Agent Martin, if you can just request that Agent Lesky would just confirm that with the Secretary of State on the CFJ 101, the basic information report, when it lists driver's license none, just confirm that there's no valid driver's license right now.
Okay.
And if there is, just change it to reflect the number. All right, Mr. Nightingale.
he did want to let the court know that his last known address is also his current address, and I think that's all for our challenges.
Okay. All right, Ms. Goodrich, any additions, corrections, or modifications to report?
No, Your Honor.
The guidelines were scored at 10 to 23 and 7 to 28 respectively. In the two cases, Mr. Nightingale, any scoring challenges?
No.
Ms. Goodrich, any from the people?
No, Your Honor.
Go ahead with any allocution, Mr. Nightingale.
Thank you, Your Honor. So Mr. Claypool comes before the court here, 40 years of age. He does have some prior involvement with the criminal justice system. He's got 12 misdemeanors, 3 prior felonies. I know that he's going to want to point out to the court that, this conviction information that, states what is essentially just the standard, the PAT language, domestic violence and or knowingly assaulting a pregnant individual, third offense. He wanted to make clear to the court that he's not out here assaulting pregnant individuals. He's here because of prior domestic violence convictions, not involving any sort of pregnancy, to my knowledge or to his knowledge. He does want to also let the court know, obviously he's got I think a pretty extensive psychiatric history, not as bad as some others, but certainly warranting medication and treatment. He, I think, would be amenable to saying to the court that, had he been taking care of his psychiatric needs, that we probably wouldn't be sitting before the court right now. I think he acknowledges that. And although, these medications that he's going to get put on again do have some side effects, that he's going to have to deal with and work with his doctor to make sure that he doesn't put himself in this position again going forward. He did plead no contest here. He's going to pay restitution of $3,200. His sentencing agreement was for incarceration not to exceed 26 months, combined for both files. We're going to ask here for consecutive county caps if that's something the court would be willing to do. He's got quite a bit of credit time in it. At this point, he's got 277 days on 7024 and 267 days on 7025. He does have one prior prison stay. He wants the court to know that he wasn't sentenced to prison as a part of that case, and I think that's clear in the PSI, right? But he wants to outline that he was revoked to MDOC on a violation. He did end up completing boot camp as a part of that revocation process. And so he does think he learned something through that, although he's here again, unfortunately, for similar type conduct. I do think that at least gives the court some comfort that he's willing to participate in programming, and he's willing to continue to try to better himself. Every time that I talk to Mr. Claypool, he's always concerned about the health and safety of Miss Claypool. He does obviously want the no contact order to be lifted as part of his sentence. I don't know if the people have a position on that. I think their position previously was to keep it in place. I'm hoping that there's a different position in talking to Miss Claypool, but I don't know that for sure. Judge, it does seem like the agent who did this PSI was unable to get a hold of Miss Claypool, and so that's unfortunate. Just period. Judge, further, Mr. Claypool is on disability, or at least was on disability. He's been there on such for about 10 years. He's certainly got some challenges as far as gaining employment. He's been doing a lot of work on himself to try to stay clean. He's got, sounds like about 10 years clean and sober. He does also want to let the court know he was attending NA classes, not AA classes. I think that might be written somewhere in this report, but nonetheless, he's doing some treatment to try to better himself. Judge, he's got good family support. He talks to his mom really frequently. He is unfortunately not a resident of this county. I think his plans are not to stay in Sheboygan. Sounds like, had this situation not occurred, that neither of them, he or Ms. Claypool, would have stayed in Sheboygan County. They probably would have gone back to Grand Traverse. That is still his intention once he's completed whatever sentence the court is going to give him today to go back home. And I think that's all I have to say.
Thank you. Mr. Claypool, you don't have to say anything today, but you're allowed to. Is there anything you want to tell me?
I would just like to apologize to the courts and my wife for, my actions and behaviors, as it's caused, obviously a lot of money for the courts to proceed through, because I chose to break the law, and it's caused probably my wife a lot of mental and emotional anguish. And for that, I apologize. There's nothing I can, if I could go back and change my actions, I would totally and utterly do that, as I regret what has been done.
Thank you. Ms. Goodrich, any recommendations from the people?
Oh, yes, Your Honor, thank you. We're here because on February 28th of 2025, the victim's mother called the police because her daughter had messaged her that her husband had hit her in the head 2 times, knocking her unconscious. When the police arrived, the defendant would not exit their camper, but he finally did. After he was arrested and a no contact order was entered, he called his wife approximately 82 times over only a few days. He's 40 years old. He was 15 at the time of his first arrest. He has 3 felonies and 12 misdemeanors. He's been on probation 6 times, served jail time twice, and prison once. He has a high school diploma. I noted that the PSI pointed out that the defendant has an excessive history of assaultive behavior extending back to when he was a juvenile. It looks like this is the fourth assaultive case against the same victim, his wife. The plea agreement was not to exceed 26 months and order $3,200 in restitution. The recommendation is for 23 months. I'm asking the court, due to his assaultive criminal history and multiple times against the same victim, to order 26 months with $3,200 in restitution. Our victim advocate had contact with the victim as recently as today, and she would like the no contact to continue through any term of probation or parole. Thank you.
All right, thank you, Mr. Claypool. If you please stand for the court sentence. Mr. Claypool presents in these two cases for a domestic assault of his spouse. He's got a significant assaultive history, and then while he's in the jail, he continues to harass her. He's pled no contest to aggravated stalking, habitual second for conduct in the jail, for repeated contacts with the victim. You know, it's remarkable, Mr. Claypool, for you to have been to prison for repeat domestic violence and then participating in the boot camp, and for you and your attorney to say you learned something there. I'd be curious to know what in the heck you learned, because you sure didn't learn not to assault your spouse. That's happened quite a bit since you've been paroled. One of them, while you were on parole, she refused to testify against you. So then they just continued you in some mental health treatment. And now you got this case. So I'm not sure what you did learn at boot camp, but you didn't learn the most important thing. And that's, you don't get to lay your hands on other people. I don't know why you think that's okay, but it's not okay. You've done it your whole life. So clearly you think that's something you're entitled to do. It's kind of part of who you are. I don't know. There's been all sorts of efforts at probation and treatment. You even back in 2006 or 2008 participated in a problem solving court, a domestic violence court. None of it's worked. So now we're just going to lock you up whenever you do it again. So in file 7024, domestic violence third offense, guidelines of 10 to 23 months. Taking all these things into account, I think the proportionate sentence is to commit Mr. Claypool to the Michigan Department of Corrections for a term of not less than 13 months, nor more than 5 years, with credit for 277 days previously served. In that file, there's restitution of $3,200, crime victims assessment of $130, court costs of $350, and state cost of $68. That's a sentence within the advisory guidelines and within the sentence agreement. In file 7025, aggravated stalking, habitual second. In that file, there is $68 in state cost, $130 in the crime victims assessment. I'm going to commit Mr. Claypool to the Department of Corrections for not less than 13 months, nor more than 7.5 years, exercising my discretion under the habitual statute to increase the statutory maximum as allowed. Also, because this was committed in the jail, my interpretation of the statute is that that's mandatory consecutive. If I'm incorrect about that statutory application, it is also discretionary consecutive, given that he committed one felony while another felony was pending, and I would exercise my discretion to impose consecutive sentencing for someone with a significant assaultive history who's locked up and then continues to hassle the victim while they're in jail. So file 7025 will run consecutive to 7024, so there's credit for 0 days served in 7025. Those are the sentences of the court, and that's within the guidelines, and it is within the sentence agreement, because these two sentences combined are 26 months. So, Mr. Claypool, if you want to appeal, you can do so by filing an application. If you want a lawyer, I'd give you one, but you have to ask me within 6 months. So we're going to hand you a couple pieces of paper about your appeal rights in both files. Ask you to initial one copy for us in each file. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Claypool?
No, sir.
Okay, good luck to you.
He thought he could keep terrorizing her even from behind bars. Biggest mistake of his life. Smash that subscribe button right now. Tomorrow, another entitled thug faces a judge with zero patience.